Copyright is basically a little monopoly you have on anything you create. That could be a written work, could be a photograph, could be software, and it usually lasts from the moment of creation to 95 years for works made for someone else, like a corporation, or a life of the author plus 70 years. After that, it's in the public domain, meaning anyone can copy it, anyone can use it however they see fit. Under copyright law, the author is presumed to be the owner. So if you want to retain ownership of something as a creator, or if you're a business and you want to make sure you actually own what's created for you, you have to consider the works made for hire doctrine. This usually means employees, within the scope of their employment, what they make, the employer owns. Anything else, independent contractors, you may want to have a written agreement to spell out who owns what and how that's handled. If you're threatened with a copyright lawsuit, you should take it seriously, even if at first glance it seems like it might not be a serious threat. And the reason is, in part, because copyright law can have statutory damages attached, whether or not it's a significant financial damage to the plaintiff. In any case, you'd want to take it seriously and consult an attorney before contacting the person who sent the letter. Idea that there are some limits to what a copyright can protect, and principally for fair use, it would mean that someone else can use a small portion of this work especially to comment or criticize or make some new transformative work that is different from the original work being borrowed from. Trouble is sometimes it's tough to figure out how much is too much, and the courts usually look at 4 different factors, none of which can be determinative. So it's best to think about it and maybe call an attorney before relying on fair use. Basically, just about anything that's sufficiently original, it's a pretty low legal standard to get something that's original, and keeping in mind that it can be protected for quite a long time. Just because you find something on the internet, your assumption should not be that it's free or public domain. Your assumption should be that it's protected by copyright. Well, technically you don't need to register your copyright to have a copyright, but what the copyright registration gives you is the ability to go to court and sue for damages. Additionally, if you wait too long to register your copyright, you may have missed the ability to collect statutory damages from infringers you find later. So it might be a good idea to register early if it's a work that you intend to use for your business.